I'm Paul Coggins, and my colleague Jennifer McCoy and I will be discussing recent trends in antitrust law, antitrust enforcement. And there's been no area in white-collar law that's been more talked about, more written about than the recent spate of antitrust cases and the renewed aggressiveness of the Antitrust Division of the Justice Department. The Justice Department, along with some of the state AG's actions, have brought some cases that, frankly, wouldn't have been brought in the past and have never been brought before in history, with decidedly mixed results at this point. So Jennifer and I are going to be walking through sort of the recent trends and what we see the future holding for antitrust enforcement.
Thanks, Paul. And I think mixed results is putting it kindly, but let's start with kind of why we're all here, piggybacking off of what Paul said. The Department of Justice and the Department of Labor announced enhanced enforcement of antitrust law, specifically in the labor market, and that's something that the Biden administration generally has announced as a priority. So in their press release announcing the enhanced enforcement, and this is just a snippet that we have here on the slide, released in March 2022, they announced that the DOL and the DOJ recognize the value of strengthening our collaborative relationship to enhance and maximize the enforcement of the federal laws administered and enforced by the two agencies. So they actually entered into this memorandum of understanding to strengthen the agency's partnerships through greater coordination in information sharing, coordinated investigations and enforcement activity, training, education, and outreach. So there will be more collaborative efforts on that front in the near future. That was just a few months ago.
Any discussion of antitrust law really has to start with the Sherman Act, which is the foundation of the Antitrust Act. And one of the things that those who don't practice antitrust all the time are struck by is how incredibly broad the language in the Sherman Act is. I mean, on its face, it prohibits every contract, every combination, in any form in restraint of trade or commerce among the several states. Well, on its face, it would cover a meeting of a board of directors of a company in which they decided what price they were going to charge or what wage they were going to pay. That obviously makes no sense and couldn't stand, commerce couldn't stand a restriction like that. And so despite the plain language of the statute, what's happened is it's come to apply only to unreasonable restraints of trade. And unreasonable is a concept in and of itself that's quite broad, quite wide. And the way that has been narrowed down is through court interpretations, and particularly interpretations of the Supreme Court, which come down, and set the parameters of what constitutes an unreasonable restraint of trade, and that changes over time.
And diving a bit further into the Sherman Act, the unreasonable restraints that Paul mentioned, they really fall into two different categories, two different ways through which they can violate the Sherman Act. So first up, we have per se violations. And per se violations include manifestly anti-competitive activities, that's the Supreme Court's wording, that are deemed to be always unlawful, regardless of the actual consequence of the activities or the intent behind them. The Supreme Court essentially has held that such activities are so anti-competitive that there can be no pro-competitive benefit. So doesn't matter what your explanation for the agreement is, doesn't matter whether or not you claim that, it was all in good faith or it was in order to really bolster competitive activity somehow or protect the goodwill of the business. A per se agreement is unlawful essentially no matter what. If there is an agreement, it's illegal. So traditionally, courts have applied the per se rule only to agreements which they have sufficient experience with. So when we think per se, usually we think of bid rigging, horizontal price fixing between two companies. So for instance, if, two gas companies got together and said that we're going to charge, $4 a gallon no matter what, that would obviously be manifestly anti-competitive and it'd be a per se violation.